Okay, please be seated, everybody. Let's go over a few things before I forget. The plaintiffs used 50 minutes today. So in rebuttal, they consumed a total of 2 hours. The defense consumed 35 minutes. So in rebuttal, they consumed 55 minutes. So I think that concludes those time clocks. Now, you all were referencing that there might be some issue with the jury instructions.
Very minor, Your Honor. On the false imprisonment in the first...
Can you give me a page number?
Yes, I can. Page 13.
Page 13.
A and B on page 13A only includes in the past. I think it should say and in the future. Or whatever language is acceptable, but I think that was unintentionally dropped out.
Wasn't this a question I sent around this weekend?
I wasn't paying attention.
You know, I think it might have been, but I sort of counted on Mr. Elliott to catch it. I didn't double check it, but I'm not going to object to this.
Okay, so we need to add or in the future.
Yes.
Yes, sir.
So what I'll do is I'll have the jurors open up their package and then I'll tell them to add those words in.
And I had a couple little things as well.
Okay. What page are you on?
Page 19 at the bottom, where it starts off with all children's, John Hopkins All Children's Hospital admits that it would be liable. For some reason, the standard sentence that would precede that, which is that John Hopkins All Children's Hospital denies these claims, got left off that one.
I had no idea it was so hefty. I don't know.
So it would be Johns Hopkins All Children's Hospital denies these claims and then go into Johns Hopkins All Children's Hospital admits.
Yes,
Any objection?
because it was midst of course and scope.
No objection.
Okay.
And then on page 41,
Mr. Elliott, were you trying to?
No, when you finish with the instructions, we need to do a jury verdict form change to match the change we just made. It's wrong there too. On false imprisonment. We'll come back to that.
on the damages.
Yes.
On page 41, when we agreed to drop the fraudulent billing down to Mr. Kowalski, I still had a them in line 3 and a them in line 5. And then in subpart A, it was the plaintiffs rather than him, and Mr. Kowalski.
Okay, so what should it read?
It should read, you should award him an amount of money that the greater weight of the evidence shows will fairly and adequately compensate him for any monetary loss. And then down in the elements, the sub A should read, any deductibles or copays incurred by Mr. Kowalski as a result of Mayor Kowalski's sheltering at John Hopkins All Children's Hospital.
We had an addition as well, you know.
I can only do one at a time. Okay, so I've got on line 3 on page 41, line 5, and then so the plaintiff should read Mr. Kowalski.
Yeah.
So 3 changes on page 41, is that correct?
That's correct. And that's all I had.
Okay, Mr. Anderson.
Judge, we believe that, and I should have proposed this over the weekend, but we were a little preoccupied, as the court may be aware. this would be a C on page 41, and then in addition to question 41 on the verdict form.
Okay, just do one thing at a time. Please don't do multiple things. So what do you want added to the language on page 41?
And or any billing by defendant of charges for medical services you determined were unnecessary and or not performed. To take into account that we have the billing in evidence and testimony that it was unnecessary and that they did not receive the CRPS billing for at least the psychoanalyst, the psychological Dr. Katzenstein charges. And in the record, we have the complete billing. We have a slide with the breakdown of those. I'm sure the jury hasn't gone in and broken them down like we have, but we've broken it down for Dr. Katzenstein charges, and we believe that if the jury thinks that based on the discharge form where there was no listing of CRPS, they want to get rid of some of those charges, it should be part of the instruction and the interrogatory
So
here.
what is the specific language you're asking to be added?
And or any billing by defendant of charges for medical services you determined were unnecessary and or not performed.
Two things. It wasn't pled. If it had been there, the expert that we brought all the way down from Baltimore would have talked about this. The impact on him for these things is in the copay for him personally, because Aetna's not really complaining about any of this. So I don't think that's necessary. And I'm not quite sure how they would, I'm not sure what the evidence is that allows them to figure out how to calculate this.
So that was your second reason.
I think, yeah, that might have been 3 reasons out of 2.
Any response?
Yes, Your Honor. The evidence came in without objection. We put the billing in. We talked about the CRPS not being performed as it should be and not being treated. And there's also a reasonable inference from the evidence that none of the CRPS billing should be charged against them. Now, will the jury agree? I doubt it. But we believe with the evidence in the record right now, there should be at least language to that effect if they choose to believe that the Kowalskis were overbilled. And the pleas collapse into the proof at trial, and we have in the billing records, we have in the coding so they know which ones are which, and we have in the testimony about the CRPS not being the real diagnosis, and of course Dr. Katzenstein giving 5 hours over the course of 97 days.
I'm not inclined to add that proposed little c to page 41.
Thank you, Your Honor.
Now, as far as the verdict form, I need to fix the question and add something to along the lines of in the future.
Yes, Your Honor. Let me.
So that means all of the verdict forms that we circulated to you all, we need to shred those, and I'll give you clean ones in the morning.
I think the problem is in question 8. The the 2 false imprisonment ones, question 8 and question 13.
I think I flagged this issue over the weekend.
I was thinking you took this out of one of these instructions when we went through it, and was there proof for these things? But that's just my memory.
Well, we're talking about pain and suffering here going into the future. I think there's proof on that. Mr. Alburn, I think what you're thinking about is that some of these, it doesn't capture. Okay.
The list.
Number 12, expenses incurred in the future after she reaches 18. And I think, and then 14 is obtained in the future until she reaches.
This is what I'd ask Mr. Elliott and Mr. Altenburn to do. Get together, send me the specific language you want me to add, then I'll add it into the file. Just make sure it's specifically wherever you need it. If there's ultimately an objection to the language, send me each party's proposed language, but I don't think this is a controversial issue.
I agree. Mr. Elliott, I probably don't need to be in the courtroom for the next 4 or 5 minutes. I can walk out in the hall. If you want to call me, we can settle this.
Okay. I don't know what's being argued next.
You might need to be here. That's true.
I think the next issue we're going to deal with is juror disqualification. That, in my mind, is where we're going next.
So, Mr. Elliott, why don't we just talk about it once that's finished?
Okay.
Thanks.
Anything else on the verdict form or jury instructions, or can I pivot at this point?
None on behalf of the plaintiff, Your Honor.
Any defense?
No, Your Honor.
We have before us a motion for juror disqualification of juror number 1. That was filed by defense. I've read the motion. I've read the response. I'm happy to accept further argument. Hopefully, it won't overlap too much what was started.
No, I'll be brief, Judge. I appreciate. I know that you read the materials that have been provided to you. I do want to emphasize a couple of things and comment, if I can.
Sure.
I would say that I understand this is a very rare motion to bring. I've been practicing for almost 40 years, almost 200 trials, and I've never had to bring this kind of motion before. So I appreciate the gravity of it. I appreciate the unusualness of it, but we do believe that it's merited in this case. As you know, you're vested with the discretion in determining whether a juror has engaged in misconduct. And by misconduct, in this case, we don't mean that he has listened to news or done none of that things. But what we're talking about is that a juror that we believe has violated the instruction to not form any definite or fixed opinions about the merits of the case until all the evidence is in and arguments of attorneys and instructed on the law. We believe that deciding a case before hearing all the evidence is the antithetical to a fair trial. And I know that Your Honor has we've pointed out some of the jury questions from this particular juror, but there are a couple I just want to emphasize. I don't have a page number, but this juror particularly, in one of his questions, started with, you and this juror are not psychiatrists, we are humans and have feelings, etc. But goes on to say, is it possible that Maya's waning abilities could all or in part be contributed to what J. Hatch was causing? The limiting of family interactions and the stress and trauma Maya has testified to, documented statements to Maya about her mother's status, told to Maya by hospital staff, Miss Beatty. Could all this possibly have affected Maya's participation in your therapy sessions? To me, to the defense, that is a clear indication that this juror has already determined what the evidence is on those issues. Okay,
so which one in your motion are you referring to? What little letter? 2A, B, C?
Oh, I don't know, Judge. I'd have to go back and connect that, and I can do that if asked. the tenor of the questions that we've addressed in our motion, and the specific questions that we reference clearly, in our view, show that this juror has predetermined the evidence. The just want to point out that in addition to those, this one specifically, Judge, and I'm sorry, I don't know if it's A, B, or C, but the question specifically states, will the jury be able to observe Sally Smith as a live witness or by Zoom during these proceedings? And goes on to say, are we able to be told, as there appears to be probable cause of improper actions of Sally Smith in her assigned role at JHatch, was she written up or coached? Is Sally Smith still performing duties at JHatch? To me, that is a prime example of the concerns that we have with respect to this juror, since he's already determined that there's probable cause that Sally Smith did harm and did wrong. To further
Even with the word may,
the word may,
did you read that may be probable cause?
I don't think it
Appears to be probable cause.
Well, again, Judge, though, it's a predetermination by this juror, his hostility towards the defense witnesses, his advising that he happens to be of the same ethnic background, and maybe we just thought she was pushy because of that. The fact that he considered one of the nurses a breath of fresh air because she's the first person to say anything nice about Maya. All of these, when you put them all together, Judge, are a pattern and an indication and evidence that this juror has already decided the case without any deliberation with his other fellow jurors, without any instruction on the law. Suggestions that the witness has overreacted, indicating his view of the CRPS. I mean, the hostile questioning of Miss Laporte. Are you attesting to this juror that you were the only one on the call? I mean, the whole tenor of all of these questions that we pointed out in our motion indicate that this juror has made up his mind. And it wasn't even, I mean, it was from pretty much after the Kowalskis testified. And from that point forward, I think the evidence shows he turned a deaf ear to the rest of the testimony, and that his questions indicate that. We think under the law that there's sufficient grounds here for this court to, in fact, change his status from being one of the jurors to one of the alternates, and that would be the appropriate to handle it. We think the Allberger case supports that. We don't think it's necessary to interview the juror. We think that when you look at Allberger, that the appellate court will support that you as a trial judge were here and could judge this matter as the trial judge. The Washington v. State case that the plaintiffs cite to, which is first DCA, the tenor of those questions were not the same, Judge. The judge seemed just to be irritated because they were asking a lot of questions, but it wasn't that the questions were hostile or indicated that the juror had already made up his or her mind. So we believe that this is the appropriate motion to bring, and it should be granted.
Now, my reading of the Alberger, and that's ALBERGER versus Harbison, HARVISON, 342 Southern 2nd, 537. There wasn't a discussion as to what the jurors' questions were. My recollection of that case was the trial judge had already determined, as a matter of fact, that the juror could not be unbiased and fair.
There's no detail in the, agree, there's no detail in the actual case as to what it was. It just said that the appellee's counsel voices objections on the grounds that the nature and manner of the juror's questions, and it was apparent the juror had shown bias and lack of objectivity. And then a juror was substituted over objection, that the juror was substituted. And we think that that is the case we have here, Judge. I mean, when you look at the totality of these questions and the hostility of these questions, as we've detailed in our motion, and I could point out some others, but I think the court has read the questions. Certainly during trial, the court read the questions. There were times during this trial when we at the bench pointed out, Judge, that seems to be a question where this juror has already made up his mind.
Let me ask you this. I mean, everyone knew that this juror was former law enforcement. I mean, we knew that from day one, given his jury questionnaire. And isn't it something that law enforcement officers do, is they confront people with conflicts in stories and evidence and see how they react? Isn't that just how a person digests information? And it's just, we knew he was former law enforcement, and therefore we could kind of expect that he was going to ask tough questions, sharp cross-examination type questions.
Well, Judge, I don't think these are tough cross-examination questions. I think these are questions that show a bias. They aren't objective questions. They are bias questions. When you talk about probable cause, when you talk about confronting a witness with, hey, wait a minute, maybe the reason Maya's having these issues is because of the fact that you separated her and you did this and you did that. Those aren't tough cross-examination questions. Those are questions that indicate a bias and that he's already determined that those facts are true.
Anything else, Ms. Crows, that you want to say?
If I can have a chance to respond to the plaintiff.
Sure. Who from the plaintiff is going to make the argument?
I will, Judge. It's interesting, the perspective, because I went back and looked at my notes from the first 2 weeks, and I had a big question mark next to Juror 1 as to whether he was dead set against our position based on the questions that he asked. He didn't say he had the same ethnic background. He said Nordic and a certain blunt way, I believe was his question. So he was not trying to identify himself, because she's from Poland, and I think he's talking about Sweden. And the breath of fresh air, he just said, period. He wasn't addressing that, and we don't know from that. What we're doing here is trying to go back and do another voir dire, or redo voir dire. This this juror, like the court said, is probing every bit of this evidence and every one of these witnesses. And thank goodness there are jurors like that out there. So just because he has asked these type of questions does not disqualify him. If anything, he seems like a pretty contemplative juror, as do all of ours. So that having been said, we don't want an appellate issue. Any more of the appellate issues than the...
Well, let me just stop you right there.
Go ahead.
Ms. Crowells is suggesting that juror number 1's status be changed from on the jury to being an alternate. So effectively not disqualify him, just shuffle the chairs. At the end of the day, do you agree doing that because you're concerned about it for whatever reason? Do you agree to do that or not? Because if you're going to agree to do that, we'll walk a certain path. If you're not agreeing to do that, we'll walk a different path. Do you need a moment with Mr. Elligott and your team to decide that? Because when it's all said and done, if you're in agreement with Ms. Crowells on changing his chair from being on the jury to an alternate.
Well, my one question, I want to confirm who takes his place, obviously, which I think is juror number 5.
Whoever was the next.
My notes have.
We're not looking to shuffle the alternates, so whoever is the.
That's what I'm trying to figure out.
My notes have, and Madam Clerk, tell me if I'm wrong, that our jurors are jurors 1, 19, our jurors are 1, 17, 19, 93, 97, and 98. The first alternate is juror number 106, the retired electrician.
Yes.
Yes, Your Honor.
That's our understanding as well, Judge.
So that's the first alternate. Do you all need 5 minutes?
Yes, Judge. I mean, we realize what we're trading out, I guess. And we understand the position of the defense is they just want to trade spots.
We just want to, well, it's not unusual in a trial to sometimes make somebody that was a juror an alternate if they fell asleep during trial, if they had issues. So that's our position.
I'm just wondering if there's an agreement obviating a ruling or is a need for a ruling. And I just, 5 minutes, let's keep this to 5 minutes because.
Less than that, I just want to give us.
Do you want me to just sit here and?
Yes, Judge. Let's just.
If you need to call Mr. Elegant, you can step outside and call him.
I think I just need to talk to him.
I'll just sit here and look pretty.
I think I better stay with number one. I don't
So
think we
you
have
were
a-
opposing the,
Yeah, I think I need to oppose that. I have very mixed feelings, but first, I think it's the right thing to do to keep him on there under the law and our system of choosing jurors. I don't see anything in his questions. I see him probing things deeply. And I think he, like I said, when we started out, I wasn't sure which side he's on, and I'm still not sure based on some of his questions.
Well,
I mean,
I think the point should be he shouldn't be on anybody's side at this point, Judge. That's the point.
They all form opinions at some point and through it, and they're all cheering for one side or the other, and then they switch sides depending on the evidence. That's the nature of jury trials.
so I need your final answer, Mr. Anderson, so we can get this thing going.
You're a lot of help.
Someone has to make a decision for the plaintiffs. So you are there. If not, I'll call Miss Lawrence. You can give me the final answer.
Sounds good.
Well, where did you?
Put it on the spot.
You'd like to sub in Ms. Lawrence's jury rule.
We're not doing that, Mr. Whitney.
No, I changed my mind. I'll go with number 5. So I'll agree with you.
Miss
Okay,
Lawrence,
well,
is this your final answer?
It's not number 5, it's 106.
Well, hang on then.
It's the one he announced, the
I'm
electrician.
sorry, 106, prospective 106. And
He's counting 1, 2, 3, 4, 5.
Yeah,
yeah,
yes.
That's
where
why
he's
what he
sitting.
meant.
Okay.
Yeah.
All depends on how you count.
All right, so are we concluded?
Miss Lawrence, is that your final answer?
Yeah,
Okay.
I think I'm going to go with that.
Okay,
Okay.
so what we're going to do
Swap
with the
them.
agreement of the parties, and this is the agreement of the parties, is juror number 106 will move into the status of being on the jury, and juror number 1 will move into the status of being an alternate.
Which alternate? Is he just going to swap with?
Is it going to
Does that
matter after tomorrow?
Probably not, but
If someone has another medical emergency, we'll address it then, but
Yeah.
let's just pray no one has another medical emergency. How about that?
I hear you.
Let's
you know
not
what,
go
Ju-
about,
You know who I didn't check with through this whole thing? My client.
well, that would be important.
Okay.
Well, let's let Mr. Anderson talk to Mr. Kowalski.
Okay. All right, then can we move to exhibits, Judge, unless you
Well,
have?
let's give Mr. Altenburn another moment.
Yeah, I'm waiting.
Judge, Mr. Altburn and I weren't able to talk, but I did send him a
Well,
text.
I'm going to go with my client. I have to switch positions because my client feels more comfortable with juror number 1. So I'm going to switch positions based on my client's input.
181 packet. Okay, so your final answer, and just so I'm clear, the plaintiffs are objecting to the switch and wants, if I were to deny the change, your client wants the appellate issue.
To such as it is, I don't think there's much of one, but
Okay. So the final answer is you're objecting.
I'm objecting.
Okay. Anything further, Ms. Crowells?
Judge, I think we've laid out the bias that we believe this jury has shown. I think that the appropriate ruling for the court is to grant the motion. I think under the case law, it's warranted. No, I have nothing further.
Court has before it the motion to disqualify juror number 1 for a question of bias. This is a very peculiar type of motion, and since normally when we see question of juror misconduct, it's they've violated some sort of instruction of the court, like don't go to the accident scene, and they go to the accident scene, or something along those lines. The court has given instructions which the defense says that this juror has violated. For instance, instruction 202.2, you must avoid forming any final opinions. Keep an open mind. Actually, keep open mind is from 201.2. In this particular case, the evidence that the defense points to has to do with juror questions, and the court will, I think, without a doubt, everyone will agree that juror number 1 asked a substantial amount of questions. Now, to be fair, other jurors and alternates, although they don't know they're alternates, also asked a substantial number of questions. For instance, juror number 181, whom had the medical issue today, also asked a copious amount of questions. What we know about juror number 1 is he's a former law enforcement officer. We've known that since day one. That's on his juror questionnaire. Everyone's known that. And certainly he survived the individual questioning, then the group questioning that we had for all of the jurors. During the course of this trial, I mean, obviously I said juror number 1 has been asking a lot of questions, and I don't know, maybe 3 or 4 weeks ago, the defense started referencing their concern about this particular juror. And certainly I've been paying attention both before, but acutely aware of each and every question that comes from juror number 1. The case law that's been cited to the court from the case for the defendants is the Allberger case, and the best case, if you will, from the plaintiffs. I think it's, where did it go? It's the Washington v. State case, which is 955 Southern 2nd, 1165. Judge Padovano, writing for the first DCA, talks about witnesses who ask probing cross-examination questions, and how that is not necessarily any indication that the juror has violated an order or instruction of the court. The court's instructions, can't form any final opinion. You have to keep an open mind. 9 weeks into this trial, I can tell you without any sort of certainty that juror number 1 has been testing the evidence in this case. Every single witness. Well, I don't think he asked a question today, but I think he asked a question on almost every single witness that wasn't by deposition. And the witness, even after the defense 3 or 4 weeks ago started pointing out what they were contending to be prejudgment, this juror continues to ask probing questions. If he had already made up his mind, why would he ask so many questions? If he had a final or fixed opinion, why would he continue to do this? Now, yes, he put a lot of prefaces into it, but I would say that his prefaces talk about context. And we have to remember that the jurors asked their questions after all of the lawyers, and perhaps this is bad on me, but I did not constrain the lawyers to a strict direct, cross, and redirect. I let them go for recross and redirect and recross until the lawyers were finished with their questions. That's just because I view this as let's find the truth. And so I didn't want artificial boundaries on cross-examination and redirect to limit us. So the point is, sometimes it might be an hour and a half, 2 hours or so, or if we've taken lunch, even longer before the jurors were able to ask their question. And if they use, let's talk about this subject, and without providing context to the question, he might have written it down 2 hours before. So this juror was providing context. I have not seen anything in my mind that would remotely come to me to get to the conclusion that he has prejudged anything in this case. On the contrary, I am warmed by the fact that he has, in his mind, gone through, or what I believe to be his mind, based on the questions that he's asked, my observation. I mean, the guy sits, 5 yards from me. I've been watching him for more than 2 months. I mean, he's the closest juror to my physical vantage point and location. And I've been watching the guy. And I have no, not only do I not have a doubt, I don't have a reasonable doubt, but I have no doubt that this guy has not come up with any final or fixed opinion. And when I reviewed the motion, the only thing that gave me any hint of an issue was the reference to the shared cultural sense of Beata Kowalski and this witness. And I went back and looked at the actual question that was asked. And I don't see anything in here where this witness suggests even remotely that he is going to vote for the Kowalskis because of that, or vote against the Kowalskis for that. To me, it's just context. He was providing a situation of how he was framing the question. And then I go back to, this is a person with law enforcement background, and he's, in my mind, taking what is sharply conflicting evidence that both sides have skillfully and artfully put forward to this jury, and he's trying to make sense of it. Now, there was a reference in the motion to, is he communicating? Obviously, there's no communication in the jury room every single break, even if it's for 2 minutes. I asked if they've been talking with each other, and the answer is no. So I have no concern that there's any hint of deliberations or discussions amongst the jurors back in the deliberation rooms outside of the court's presence. So I don't see that as the case. So the only evidence here is his demeanor in front of me, plus the questions that he's asked. And I don't even get to the point of whether I need to discuss whether I need to have a conversation with him, because I'm not even close to the question of whether I have a reasonable doubt as to whether he can be fair and impartial, whether he has violated any court instructions. And I've seen no evidence that he has violated any court instruction. On the contrary, I think he's been doing exactly what we've asked the jury to do, which is, if they are so inclined to ask questions, and he's using his skill and expertise as a former law enforcement officer to do that. And that doesn't mean asking sharp questions, as Judge Padovano points out in the Washington case. That doesn't mean that the juror has come up with any sort of final or fixed or violated any instruction of the court. So I don't think I need to say anything more on that. So I'm going to deny the motion to remove juror number 1 from the juror. Juror number 1 will remain on the juror. The alternate, number 106, the retired electrician, will remain as an alternate. Okay, what's next?
Judge, we have some exhibit-specific issues. Given the number of exhibits, not that many, but we were back and forth on the weekend on some of it is the language
Are we talking about the neutral statement in the
Yes,
Excel
yes,
spreadsheet?
yes.
Okay.
So, Exhibit 2165, Judge, is, the access log, and that's fine. But then for 2165A, which is just one page of it, they want to put Johns Hopkins All Children's Hospital access log. I'm fine with that. Access, Dr. Sally Smith, that she accessed it that day. I'm saying you don't get to put why you put the access log in. It should be just Johns Hopkins All Children's access log 10/8/16.
You know, Ms. Lawrence, you're going to be making this argument. Just to forewarn you, you're going to come up and you're making this argument. You're an attorney. You get to make the argument.
Judge, so that's the issue.
Okay. Ms. Lawrence.
They want to say why they put it in, that Dr. Sally Smith accessed it that day. I'm saying just the date of the access log gets put.
Can I see what the physical document is that we're talking about?
Oh, I don't know. Clay, can you put up, or can you put it up? It's your exhibit.
So Mr. Cottrell's computer just crashed. So Mr. Reyes, can you help us out real quick?
His computer crashed?
I don't know. That's what I lip read over there. Am I correct?
Yeah, it's restarting.
What's the exhibit number?
Sure. It's Defense Exhibit 2165A.
Okay, Miss. Well, let's bring up the exhibit so I know what we're talking about.
So Judge,
Which page of this?
that is just one page. It's 2165A. They put in the whole access log as 2165. They put this in as A. It's the access log from a particular date. I thought it was 10/7. Maybe it's 10/7. And we just say the date should be put on there. They want to put that this is the date that Sally Smith accessed the log. They want to put her name.
Well, do I see Sally Smith's name on here?
I think it's on there somewhere, Judge. My objection is that we've been neutral in all the other
Well, I see
things.
Matthew Higgins.
Yeah, there's other people. That's correct, Judge.
Right, but what I'm saying is, I'm not seeing Sally Smith. So is this the right page?
Oh, it should be. It's 2165A. That's what they.
What's the internal page number?
There's 234 pages, Your Honor.
Which page
I'm
are you on?
sorry. My fault. My fault, Judge. 71.
71.
Okay, Miss Lawrence, your argument.
Okay. It's a factual issue. It doesn't say that Sally Smith is an apparent agent. Everything else has been redacted, right? On the
Other pages,
on the
yes.
other pages. This is to orient the jury to see Sally Smith's name.
Anything else, Ms. Carls?
No, Judge.
I mean, the whole point is to help the jury find things. So I'm going to agree with Miss Lawrence's argument. We can leave in Sally Smith.
So what exactly are the wordings? So I have 10/8/16, and you just want to put Dr. Sally Smith access the log? I mean, Judge, that's, okay. What is the exact wording you would like?
I think, however, Kelly has it on there is fine.
Well, I don't have that because I changed it. Just put Dr. Sally Smith? Is that acceptable?
You
Sally
already
Smith.
said it was access log hyphen Dr. Sally Smith.
It says John Hopkins All Children's Hospital Access Log -10/8/2016. And then we can add Dr. Sally Smith.
Yes.
If that's what you would like.
That works for me.
Okay. The other one is, so, Judge, to aid the jury, we broke down the hospital admissions with neutral indexes. It's just what they're called, right? So we did it for the joint exhibit for the hospital, and then we did it also for Lori and Tampa General Hospital records. Their objection is that it's not done for all of the records, and it gives emphasis to these records. My response was, break out what you want. If you want other records broken out so there's an index so juries can find the discharge summary, or they can find consult notes or whatever, feel free to do that. They said we don't have time. So their objection is that on 3032, we broke out, and I'm happy to show that, Your Honor,
Yes, please.
if I could just. So you can see on 3032, for an example, we broke out a particular hospital record, simply giving an index to the jury where to find the particular title of those documents with no description or anything. We also did it for 3047. Their objection is that that somehow gives emphasis to those records. We were just trying to aid the jury. They don't object to the joint exhibits that were done, which were the Johns Hopkins records.
Ms. Lawrence?
As long as we're free to specify everything else, then we're okay with it, but it's gonna get pretty convoluted if we start.
When you say specify
Yeah, I don't know
everything,
what that means.
If we're parsing out every other exhibit.
No, just the hospital records.
within these two hospital, or are you talking about other
All of
locations?
them.
Other
for
Eagles Wings.
Eagles Wings,
Well,
Shoshana Duncan,
Judge, again,
it's gonna take a while.
let's be clear.
Well-
These are massive hospital records, and all we did was put an index where to find whatever the document was titled.
Here's, anything else, Ms. Lawrence?
No, thank you.
Here's where I'm at. I am fine with what the defense has done for Lurie's and
Tampa
General. If the plaintiffs wish to do something similar before we come in tomorrow morning and it gets incorporated into the list, knock yourselves out. But do not make it argumentative. Do it very generically, blandly, like the Ms. Croyles
Yeah,
stated
Judge,
it.
I would suggest it needs to be limited to records that are, 500, 600 pages, the hospital records. If they're going to start breaking out every index for the Eagle Wings, I mean, that's going to make this 300 pages long, for one, and we're going to have to go back and do that. I mean, I don't understand their objection to the hospital record being done.
What is the
Yeah, what is
scope
it?
of the
Yeah.
documents that are in evidence that you're contemplating having some sort of breakout in?
Dr. Hannon, Dr. Kirkpatrick, Eagles Wings, Shoshana Duncan.
How many pages are there each one? Are we talking more than 50 pages, more than 100 pages?
Likely, yes.
Judge, that's a completely different category. These are hospital records that are, like, how are you going to break out Dr. Kirkpatrick's with some neutral thing? Office visit of? They're going to detail every office visit? I mean, we'll take it back. We were just trying to aid the jury when they go to these records. Where's the console? Because they have hard copies. They can't search them.
I think we're going to give them a flash drive, I thought.
But that's going to search this. It's not going to search the records.
Correct. So, which is why I am fine with adding the detail that the defense proposes, and I'm also fine if the detail, if the plaintiffs wish to do this, but make sure it's in a neutral fashion and
Okay.
email
Then we'll be going back to detail all of ours then too.
Look,
Why don't we have a conversation?
Look, I think, and maybe this is an arbitrary number, but if we've got more than about 40 or 50 pages, then I think you might want to do it. If it's under some manageable level, probably don't need to do it.
Okay.
And I just don't have enough knowledge as to how many we're talking about. But we're not stopping the jury. We're not stopping all this to let this happen. So if you want to do it, more power to you. But we're not stopping.
All right, Judge, another issue is for their description of 2032, which are the suicide notes of 2017, they put suicide notes on 1/7/2017. I was fine with that. So then we, for our, for 3212, those are the suicide notes from 2016. So we called them suicide notes 2016. They say, no, we object. You have to put just as an email. So we're like, well, if you're calling your 2017 notes the suicide notes, I think we get to call the 2016 emails suicide notes.
Did you call them the draft? Because I think that's what was referenced in front of the jury.
We can call them draft, Judge, if you'd like. Let's see. What I put?
Let me hear from Ms. Lawrence the position of the plaintiffs.
Can we put the 2016 on? I'm not sure what she's doing.
Sure, what number are you talking
Sure,
about? Just-
3212 and 3213. They're the exact same language as the, we can put draft.
Well, those are both 2017.
That's the objection.
No, that's, yeah, no, but it's January 6th. I'm sorry. It's January 6th. If I misspoke, I
I
apologize.
thought you said 2016.
I didn't mean that. No, it's January 6th are the defense exhibits. They put in the January 7th one as the suicide notes. We're saying these are January 6th suicide notes. The date and the word suicide notes, like they did for the 7th.
Ms. Lawrence, your position.
We're agreeable to putting it in as a draft.
And I think earlier you said you were okay with adding the word draft. I think that's what they were called in front of the jury. That's my recollection.
I'll confer, but that's probably okay.
I'm okay with adding the word draft to it.
Okay. Let's see. I think that might be it, Judge. As far as descriptions, we have a couple exhibit issues, though. I don't think will be controversy, but I just need to clear it up. So the plaintiff put in Dr. Henschke's records, and they put them in with redacting some pages that we objected to, as well as they should have also been some language redacted. We then, on our own, also put them in. I just want to withdraw them because I don't think they're redacted. It's 3025. So we want to just withdraw 3025 because the records are already in and they should be redacted the way they've been put in.
Ms. Lawrence?
No objection.
Madam Clerk, are you okay if we do that? So we will remove from evidence 3025. Do they need to remain as marked, or are they just able to go back? And I just don't know the answer to that. Okay.
Okay.
So it sounds like 3025 is withdrawn and no longer in evidence.
Okay. The other issue, Judge, is when I was going through this, the actual records, trying to separate them out, index them.
And I appreciate you doing that. And I think the jury will appreciate it too.
Yeah. We, I'm trying to find the exhibit number now. I told you guys earlier.
3023?
It was a joint exhibit. If I could- Yes. The 1030 joint exhibit says Arnold Palmer Hospital 11/12/20 admission. I asked, did you guys check?
We cannot check it. We cannot remove or double check to see if they're the same exhibits.
No, but it, okay.
We do have them.
So here's what happened, Judge, sorry. I noticed that the 2016 admission was also in that exhibit that was on my computer as 1030. Plaintiff said, well, you got to remove the 2016, which we put in later. We're happy to to remove those pages. I just wasn't sure how to do that. So
I guess I'm not following what you're...
Sure. So we put in evidence, Exhibit 1030. We called it Arnold Palmer Hospital 11/12/20 admission, but only pages 1 through 467 are the 11/20 admission, 2020 admission. When you get starting on page 468, it's actually the 2016 admission, which we have in later.
Okay, so 1030 is a joint exhibit,
Yes.
and the plaintiffs do not want the 468 and beyond pages in 1030. They want it separated out.
That's my understanding from Kelly.
Okay, so, Madam Clerk, are we able to make Exhibit 1030 only pages 1 through 467 and then remove 468 to the end? Are we able to do that without causing you problems?
for a second.
You can. Can I just double check myself, please? I don't want to do it and then. Yeah, that starts the 2016, and it goes to
And Ms. Lawrence, do you need to, or want to look at that exhibit?
605. So this is the 2020 admission. Yeah, when both sides have had it forever as this admission number, but it didn't notice it till we started indexing. So our suggestion is we just remove it back because we have that in separate entry. Okay.
I think there's a conspiracy talking about Florida State football back there.
I'm all ears.
So Judge, we're good on that?
Those hand signals, Lieutenant, are not accepted in this courtroom.
We're getting there.
I don't know, you're
Okay, so going back to the business at hand, we all agree that pages 468 to the end are going to be removed, and so Exhibit 1030 will only be pages 1 through 467. Ms. Lawrence, is that correct?
Correct.
Ms. Croyles, is that correct?
Yes.
Madam Clerk, you agree? Perfect. What's next?
I think that's all I have, Judge. You can see we've been going back and forth, different colors when we've been communicating. I believe that's all. We just need to confirm with the clerks that we're good on exhibits that they need. I think we are. And then, of course, we'll talk about what we're going to do with descriptions, because I don't think either side wants to be up till 2 a.m. arguing over things
I
or
know
doing
I'm
things.
not going to be up.
And I would like to walk in with an agreed exhibit list. So,
So the question is, are you going to insist on doing that to Lurie's and TGH? And if so, like for example, Arnold Palmer and Dr. Patrick, which are both well in excess of the 40 or 50 pages, we don't want to be up late either, but we're going to draw attention to certain things as well.
I guess I don't understand why you think it draws attention. It's simply an index of a hospital record.
Well,
Can we just agree to do hospital records?
y'all know my position on it, so
Yeah, we'll talk, Judge.
y'all
Sorry.
can work out the details without me sitting here.
Okay. Yes, sir.
Are you finished with your
I am.
issues?
I am.
Mr. Altenburn, you seem to pop right up.
Because we're appellate lawyers, we got this solved.
I'm up also, Your Honor.
Yes. And so the language that needs to be added to question 8 and 13 on the verdict form.
And is this something that you've emailed to me?
I believe, I asked Tom to do that, but I think he's still stuck on the Zoom too, so.
I would have, except that right now my email is not functioning from here, so I have to, I'm going to talk to our IT person when we get off. It's 7 words in 2 places.
Yeah.
So I understand.
We can send you an email, but what it's going to be is an add to question 8 and 13 of the phrase, "and to be sustained in the future." That's it.
If you could just email that to me,
Okay?
I would appreciate it.
Not a problem.
Thank you.
And it would go right after where it refers to the sustained in the past.
I don't have it up in front of me, so.
No, I understand.
So are you relinquishing the lectern, Mr.
Yes,
Altenburn?
I'm finished. If you're finished with
Mr. Alligator, have you relinquished the virtual lectern?
I'm done, Your Honor.
Ms. Lawrence, are there other issues that the plaintiff?
Nothing further from the plaintiff.
So let's just talk for a moment about how tomorrow is going to go. So we're going to arrive here at 8:15. I've got some words that I'm going to talk tomorrow, which will probably take 10 minutes. My hope is that the Excel spreadsheet issue will be a non-issue by tomorrow morning, that there will be a singular flash drive that both sides have looked, that you can give us so I can give to our IT person to make sure that there's no bugs on it.
Can I just, so I was just going to download whatever final list we agreed to on a flash drive, is that what you're saying?
Right, but it needs to be a clean flash drive that has nothing else on it, because it's going to go to the jury,
Take the family pictures off.
and both sides are going to look at it.
Oh, like the flash drive? Sure.
And then the flash drive, before we stick it into any computers, will go to court IT, who will scan it for viruses. Because even though the computer that is in the jury deliberation room has no access to the internet or whatever, I don't want
that computer getting a virus. So.
I don't want the bill for that either. So, yeah, let's do that.
Okay, so that's what we're gonna do with that. Now, we're gonna bring in the jury about 8:30. We're gonna give closing arguments. There's 2 hours per side. I'm assuming Mr. Anderson is gonna wanna reserve some amount of time. Do you have an idea as to how much he's gonna?
It's going to be approximately an hour and then an hour rebuttal.
We object. We object to that, Judge. That's not rebuttal.
An hour and 1 minute and 59 minutes in rebuttal.
Judge, we object.
I'm thinking probably an hour and 15 to an hour and 30, somewhere in that range.
Understood.
Okay, because this is not going to be.
Yeah.
Here's 5-minute conversation, and then I'm gonna unload everything in the hour and 55 minutes I have.
To the extent it matters, Judge, the defense objects to them reserving more than 30 minutes for rebuttal. That seems, again, not rebuttal, but just a tactic, as they always accuse us of doing.
So, in any event, we'll only take short breaks for stretch breaks, restroom breaks. We're not going to break for lunch. We're going to go straight until we finish the closing arguments. Then I will go read the last couple of instructions, go over the verdict form. Now, I do want and need the lawyers to go through the evidence and ensure that it is what it is and that there's nothing inappropriate. I personally am fine if you do that quietly during closing arguments. But what I don't want to have happen is for us to do our closing arguments and then you all want to spend an hour with the clerk going through the evidence.
Huh.
And so if we're going to do that during closings, where physically would we be to do this?
Over there.
All right.
If that's okay with, are you okay with them doing that quietly during closings? Or would you rather them wait till after closings?
It'd be a lot easier if we waited, Judge. I'm just saying. I know it's not my call, but
Well, I just don't want to spend an hour watching the lawyers look at exhibits with the jury sitting there, ready to go.
so you can't send them out without the evidence going with them.
I'm not going to do that.
Yeah, I hear the honor. Can I ask, so are the exhibits in binders and we would just flip through them? Are they individual sheets?
They're all in binders. We kept them all in the binders, in numerical order.
Okay. All right, well, if we can sit over there, Judge, so we're not standing and being a distraction.
Are you okay with that during the closing arguments?
Yes, sir.
I mean, if you're not, then that's fine, and we'll do it after. Or conversely, you want to do it tonight. But that means y'all have to stay longer, and
Either way, Judge,
And
whatever is
that might
best
have
for the
to
jury.
keep the courtroom deputies here as well, so that's a lot of overtime.
I'm assuming we couldn't remove them to a conference room and do it during closings. We'd have to leave them in the courtroom. Yeah.
They're not leaving the
Yeah.
custody of the court.
Understood.
But I can sit down there and watch them go through it, if that's easier.
There's a couple of mediation rooms around the corner.
They won't look like that.
Well, do you want to physically move them into a different location in the courthouse to go through it if one of you sees?
Yeah, I'm fine with that too.
So just go to the little room right out here
Yeah. You're talking about tomorrow.
tomorrow.
Yeah, that would be a lot easier, Judge. 'Cause
But that would be during closing arguments.
I understand. I don't know who from their side is willing to do that.
We don't need to look at it. We've been checking throughout, so whatever's easier for you.
I think it's the court's requiring us to look at it.
I-
I don't think it's a request.
Then
Then we're happy to look at it wherever.
Yeah, that wasn't my suggestion. The
I-
court's requiring
I
us
thought
to
you
look at it.
hadn't looked at it yet.
I'm giving, because what I don't want to have happen is something inappropriate going back to the jury and someone saying mistrial because we didn't look at. Now, if you want to have a paralegal look at it instead of a lawyer, I'm fine with that. But I really want fresh eyes on this issue. Too much is riding on this for a silly, careless mistake that could undo this entire trial, and I just want to avoid that. So,
That's fine. Ms.
So-
Dunn will take a look at it tomorrow.
okay, and we will do that. We'll wheel it out into.
Yes. And Your Honor, is that only the plaintiff and the fence, it's not the joint, or also the joint?
Joint, any exhibit that is actually introduced in evidence, I want them to look at it, because I want them to be able to, and I'm going to ask the question, do you agree that there's nothing inappropriate going back and we only have the admitted evidence going? That's the question that I'm going to ask.
There have been a lot of redactions and things in this case, Judge, so I hear what you're saying.
So just have your person or team ready to go for that. And I just don't want to have to spend an hour after we finish closings to
I understand.
effort this.
So we'll do that at whenever, right before closings.
8:30 in the morning after we
Yes.
start closings. Or you can even start before that. I
Okay.
don't particularly care. Anything else, or can I let you all go and
Nothing further from us.
Nothing here, Judge.
okay, we will be in recess until 8:15 tomorrow morning. 8:15, we are in recess.